Good evening and welcome to the Thursday, May 9th, 2013 edition of the Planning and Zoning Committee. The first item on our agenda is a call to order and the Pledge of Allegiance. So I'm going to ask Maria to lead us in the Pledge of Allegiance this evening.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Welcome, everyone. The second item on the agenda this evening is the approval of the minutes from the April 25th, 2013 P&Z meeting. Do I have a motion on that?
Move to approve.
Second.
All in favor?
Aye.
Any opposed? The motion passes. Item number 3, we have a pair of public hearings. Number 1 is the request to dismiss George Mabe's appeal of the County Community Development Director's decision to find no vested rights and deny Ocean Concrete's site plan application for a concrete batch plant. I'm going to begin by asking if any of the members of the Planning and Zoning Committee have had any ex parte communication in regards to this public hearing, or indeed even the second one, that may unduly influence their ability to render a fair judgment on either of these issues tonight. If you have had any, please speak up. If not, your silence will inform me that we can proceed. Okay. There's no swearing in, correct? We just turn this over to...
Yes, you may. Yes, you'll have to swear. The people that are going to be testifying tonight in either hearing will have to be sworn. They're quasi-judicial matters.
Okay, thank you. So I'll turn it over to the county.
If you're going to testify, would you raise your right hand, please?
If anybody plans on testifying tonight in either of the two hearings before the Planning and Zoning Board, they need to be sworn by the clerk. Thank you. Oh, I'm sorry.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? I do.
I'll proceed, Mr. Chairman. For the record, I'm Stan Bowling, the County Planning Director, and the issue before the Planning and Zoning Commission tonight for this item is it's narrow. It's whether or not an appeal that's been filed should be dismissed. It's really based on the county's kind of common sense requirement that for any application, the applicant has to either be the owner of the property or have authorization from the owner of the property, and if they don't, then the application or anything related to the application, like an appeal, cannot proceed. There is an abbreviated history of the Ocean Concrete site plan application in staff's report, and I won't recite or try to go through a timeline of all that, but I will start with the decision that is the subject of the appeal and the appeal itself, and just recap a few of the highlights, and then turn it over to County Attorney Alan Plakowich. In the spring of 2011, there were 3 things that were essentially going on at the same time. One was that community development staff and staff of other county departments were reviewing a revised site plan of the Ocean Concrete project. In addition to that, the county attorney was reviewing a vested rights argument and materials supplied by the Ocean Concrete applicant, Mr. Mabe, the Ocean Concrete applicant's attorney, and doing research and developing a legal opinion on whether or not vested rights applied. The vested rights that were the issue is whether or not the Ocean Concrete site plan was subject to kind of older regulations that were in effect at the time the site plan application was filed in 2006 or not. Also going on in the spring and in the summer of 2011 was foreclosure proceeding regarding the site that the Ocean Concrete project was proposed for. And the county attorney did render a legal opinion, a written legal opinion, that Mr. Mabe had no vested rights with respect to the site plan application. The community development director rendered a decision essentially kind of relying on that legal opinion that the site plan was denied because there were no vested rights. And the foreclosure action continued. At the end of May, a few weeks after the community development director's decision was issued, Mr. Mabe filed an appeal of that decision. That was received by staff, and that appeal is essentially in the jurisdiction of the Planning and Zoning Commission. That's who hears the appeal of the community development director's decision. At that point, staff coordinated with Mr. Jeff Smith, Mr. Mabe's attorney, on setting up a time appropriate for the hearing, taking into account that at that point in time it was summer, that many witnesses would need to be called and so forth. So there was a bit of back and forth coordinating, actually from June all the way into October. Meanwhile, the foreclosure action proceeded, and ultimately there was a foreclosure and a sale of the property through that process. In February of 2012, the issue of whether or not to dismiss was brought by staff and the county attorney to the Planning and Zoning Commission. And at that time, and this is reflected in minutes that are in your report, I think the engineer for the project, Todd Smith, suggested that the Planning and Zoning Commission table a decision on dismissal because there still was in the courts an appeal of a foreclosure action. That was done. No one objected to that, and it was essentially held in abeyance what to do with the appeal. That foreclosure appeal process is now complete. Mr. Mabe does not own the property and has not provided authorization from the property owner for the application to move forward. And so we're bringing the decision to dismiss back to the Planning and Zoning Commission. And essentially, again, what is recommended is that the Planning and Zoning Commission dismiss the appeal filed by George Mabe due to a lack of ownership or authorization from the owner of the property, and authorize the chairman to execute an order dismissing appeal, which is attached in staff's report. I'd like to also just mention that this involves the appeal and what's happening in terms of the county's process. There is a lawsuit that is in motion and in the courts that essentially addresses whether or not the county did anything adverse to Mr. Mabe and whether any damages would be owed, that sort of thing. So that is going on in the courts, and that's separate from this particular action. I'd like to turn it over to Alan Plackowicz, the county attorney, to add his comments and be available to answer questions.
Good evening. My name is Alan Plackowicz. I'm the county attorney. As Stan indicated, back in May 2011, the community development director entered a final decision denying the site plan application of Mr. Mabe. Mr. Mabe took an appeal of that, and while the appeal was pending, a simultaneously pending foreclosure resulted in a foreclosure sale and Mr. Mabe losing title to the property. At that point, the community development director came to me and essentially said, what's the impact of the loss of his ownership on this pending appeal? And the first thing we did was we made sure that we gave Mr. Mabe ample opportunity to get written authorization from the new owner of the property to proceed with the site plan application if that was possible. We've afforded him that opportunity, never had a response, and to this day, we've never had any information that the owner gives him any authorization to proceed. So that leaves us in the factual situation that Mr. Mabe at this point no longer owns the subject property. And the question today is, what's the impact of that on this pending appeal? I rendered the opinion, I did it in writing, and I'll render it again verbally tonight, but my opinion is that the code is clear that to proceed with a site plan application, the applicant has to own the property. I think that's clear from the code. And I don't think it makes any difference at what point in the process he loses title to the property. So for example, if he had applied for site plan application or approval, he'd filed a site plan application, and 1 month later had lost title. At that point, I think the county would have lost any ability to ever grant that site plan application because he doesn't own it. And I think that's what's happened here, whereas it's happened later in the process, it still doesn't make any difference. And the reason for that rule that you have to have ownership is because in the absence of ownership, there's no way the county can grant the relief that he wants, which is site plan approval. If you look at the notice of appeal that he filed, the action that he appealed is the denial of site plan application. The only relief you can seek is approval of the site plan application, but if he doesn't have title, there's no way this board, there's no way that Mr. Keating at his stage or this board at this stage could possibly grant that relief, the site plan application. And I think if this board were to try to somehow proceed in the absence of an ability to actually grant a site plan application, at that point you're kind of off in a world of hypothetical decisions or advisory decisions or things like that because you can't grant actual relief. And even in the court system, advisory decisions or advisory jurisdiction to enter advisory decisions is extremely rare. I've been practicing whatever it's been, 30 some odd years, and never once been involved in any type of advisory case. And certainly this board doesn't have any jurisdiction to do that. I think that, I have no idea what the applicant's going to say, but I think actually the applicant would just soon see this dismissed because they're now in court, they have revised their complaint, they've kind of teed it up, and we're about to tee up our defenses, and off we go in court, and that's where this issue is going to go at this time. The last thing I would mention, I think that in fairness, Mr. May paid an appeal fee for his appeal because of the circumstances that have developed where actually, if you choose to dismiss, not going to have that appeal hearing. I think in fairness, you ought to give him back his appeal fee. But I have nothing further to say. I'll be happy to answer any questions you have.
I'm going to have some questions, but I'd like to hear from Mr. Mabe first, if that's okay with you.
Anybody else? Thank you.
Good evening, Commissioner.
Good evening.
Did you have a question that you wanted me to answer?
I'd really just like to hear I may.
Well,
What's going on?
I think, and I apologize that you had, this thing lays in your lap tonight as a denial of this thing. I think it should have been heard. Yes, I did pay for an appeal years ago, actually, and that was the total cause of this thing as far as how it related to the foreclosure and so forth.
Could you
it was
identify
withheld from you? Pardon me?
Could you just identify yourself for the record, please?
George May.
Thank you.
Ocean Concrete.
And also, could you just pull that microphone a little bit closer? That's going to help me. Thank you.
Yes, sir.
Thank you.
I think had we had the opportunity to have this appeal heard, I perhaps could have been in a different situation. It was withheld from me. It was withheld from you to make the decision at that time, and here we are for a denial. So thank you. I appreciate your acknowledging that I never did have my appeal, and I think that that's just a huge travesty of justice that I go through this process and lose the property, not because there wasn't ample time to have it, but because it was dragged out to a point where it was too late to make any difference. So at this point now, deny it if you feel you must. I'm sure the courts will ultimately rule on this thing favorably in my situation, and that will put me back in a different position. At this point now, I think I only have a couple of questions, and I'm going to ask Mr. DeBrawl with regards to the insurance company involved in this case. There's multiple years of things going on here. I've written a letter to the insurance provider, giving her notice that this thing is going on. I realize it's 6 years later, but is the insurance company involved in this case in any capacity whatsoever? Have they been notified of what's gone on here?
What insurance company are you?
Errors and omissions policy.
For
The
whom?
county's actions. You know where it is, Alan. Commissioner, would you like to answer that question? Have they been notified of what's going on here?
I'll be happy to address that outside the context of this hearing. I don't think that issue has anything to do with this hearing.
And I'm going to agree with that. I mean, the four of us, we don't even understand exactly what you're talking about, so I'm not.
Well,
sure.
I think that this thing has gone to a point and it's escalated, and the liability grows every year, and it's grown to a point now where I think it's just a little bit too much to bite off, okay? And I look at these young children in here that are gonna have to grow up and be exposed to this type of activity. You know, I think it's just something that needs to be made an example of. And should the insurance company have seen this years ago, and that's a big question for me, this would have ended immediately after a proper review. So my question is, and I know we're in a position now, we've hired outside counsel, happens to be Alan's old law partner, but I think we could have chosen anybody to defend this case. The other thing is, I think that's something that the community should have had some involvement in. I think the sunshine laws clearly say you have to put that in front of the community to see for proper advice. This is one of those things. There are some local remedies for the county that you guys can evade the sunshine laws. And I hope somebody in here is able to see clearly what's going on and maybe make a difference here going down the road. I'm going to do my thing to straighten out some of this mess. And
Well,
I'm done. I mean,
not all
deny
of
the
us,
project.
Not all of us up here have been here for the entire 6 years, so
I understand.
you need to be a little,
Sir,
you need to be a
again-
little patient with us. But let me ask you this, because help guide me a little bit, because
Yes.
I'm unclear. I know what the county wants us to do tonight. What do you want us to do tonight?
Well, we're talking about a vested rights appeal, and you're telling me I don't have a vested interest here in this property. I still have a vested interest. I never had the denial of this thing, and I'm going to have to ask the court to give me my vesting, okay? So.
But we're not the
this is a-
court. We have to
I
make
understand. This
we
is
have,
a-
we have to make a decision either to, grant what the county has requested us to do, or some other remedy, some other answer. Help me understand, what is it that you would like us to do?
I think at this point, it really doesn't matter. The damage has been done. I think it's unfortunate that you're in that position to have to make that decision. I truly am. It should have been a fair and thoughtful process. The whole thing should have been that way, but it wasn't. So we'll shake this out from our end.
There's a lawsuit. We're not the judge or the jury, and we're
Understood.
only apprised of a certain number of the facts. We're not part of the discovery, the depositions, any of that. So, I ask for your patience in that, but
What you really should have seen was our vested rights presentation. And although Alan says it would have taken some type of error in omission or fast legislation, I mean, this is something that stripped 31 uses in 4 months, and
let me ask you this.
It wasn't
Maybe this is a
thoughtful
good
land
question for
use.
your attorney, but this matters to me.
Yes.
Okay? What matters to me is that when you guys get to court, everybody's goes in on level ground. Is it your opinion, is it your attorney's opinion, that by granting the county's request tonight, that in some way, and they're asking me to sign this order, that would prejudice your case in terms of it being decided for you or against you or anything else? Will this make any difference, us signing this, in terms of you getting your fair day in court? That
I
matters to me.
think it looks as though procedurally you may not have any other options. I mean, I am not clearly the owner of the property any longer. I don't know, Jeff, if there's any advantage. I would just say
Doesn't
deny
matter.
it. It's unfortunate that's in your hands. I think if you'd have got a good look at really what went on here, you might have ruled differently. Thank you very much.
Thank you, Mr. Mabe.
I'm Jeffrey Smith, Smith & Associates, 1499 South Harbor City Boulevard, Melbourne, Florida. Attorneys for George Mabe, the former property owner, and Ocean Concrete, Inc. Thank you, Commissioners. Very briefly, I cannot stand here and dispute what Mr. Bowling and Mr. Plakowicz have said in terms of Mr. Mabe is no longer the owner of the property. His site plan application can no longer be approved. And this body tonight can't overturn the decision of the community development director to deny Mr. Mabe's permit. So there's, you know, on that we agree. That's probably about all we agree on. I believe, and just for the record, I think the frustration you hear from Mr. Mabe is that the county's actions over the years in delaying what should have been done on his first effort to get his site approved, the actions of the county were just deplorable in the way this whole thing happened. And right down to the end with this body and this appeal, the county deliberately tabled his appeal and did nothing so that the foreclosure could occur. In other words, we're not going to give you a chance to redeem your property by coming here and having this body say, yes, maybe you do have vested rights, Mr. Mabe. Instead, we're going to table that for a while because we want that process of foreclosure to conclude so that you lose your property and then you end up here tonight in this situation. So here we are. We do have a lawsuit pending, and those issues will be addressed there. I apologize if it sounds like my tone is chastising to this body, because frankly, this body was the one place where I think Mr. Mabe saw some semblance of rationality, because when he came once before to this body, when the ordinance that is at issue, this body, the majority of them said Mr. Mabe's property clearly ought to be, in fairness, ought to be grandfathered in. Everybody up there saw it, and it should have been. It wasn't, and all of that will be hashed out in the circuit court action. But I do agree that we can't approve a site plan when he's not the property owner.
Okay, so we are not here to adjudicate that issue, but what I hear you saying is that the troubling question is, I mean, let's face it, the troubling question is, which I have no opinion on, wouldn't matter if I did anyway, is whether when the county changed the code, which was after he had made application, did that contribute in some way to Mr. Mabe's losing control of his land? And that's going to be decided in the courts. And now you can understand why I asked you. I want to be very careful to ask you this question. If we grant the county's request tonight, that is not going to that's not going to be a problem for you bringing forward your case. Have you reviewed the order that they have asked me to sign?
I would like to look at that order.
I would like you to look at that order. Can you please
Just
provide him with a copy of the order that you've asked me to sign?
And I can do that quickly. I mean, if it's simply an order of dismissal of an appeal on the basis he's no longer a property owner.
And Mr. Chairman, the entire packet, of course, was emailed to Mr. Smith.
No, I understand.
I would simply say that I think a lot of the facts here have been slanted to present a case of the county. I think that what we would ask is that if there's going to be a dismissal because Mr. Mabe is no longer a property owner, it should be very simple. Mr. Mabe's no longer a property owner. The Planning and Zoning Commission can no longer grant his site application, period. All this other nonsense of we agreed, we never agreed to table his appeal.
Okay,
and
I
I appreciate you giving me the opportunity to clarify that.
Thank you very much.
Thank you.
Wait, before you stand down, is there anybody else up here who would like, do you have any questions? Mr. Smith.
Just at any point in this process, did Mr. Mabe ever prove he was the owner of the property? At any point during this process from 2005 to current date?
Oh, certainly.
Okay.
It was never, it was not
Up
disputed.
to what point?
It was not disputed until the foreclosure, until after
Until
the
after
appeal
the
was
foreclosure.
pending here and the foreclosure became final.
All right, thank you.
Thank you.
Any other questions of anybody?
Mr. Chairman, just on the order question, I wrote that order based on case law that says the board has to make findings of fact and conclusions of law. I don't care if we want to strip it down. I tried to write it in the most sterile language that I could. I don't care if we strip it down, but I don't want them complaining someday in court that we didn't have findings of fact and conclusions of law. And if they'll agree that the order that Mr. Smith just said would satisfy him, namely, the board finds he doesn't own the property, therefore the board doesn't have jurisdiction to hear the appeal, it's dismissed. I'm okay with that.
I'm okay with that, too.
And I think that's what it should say. The finding of fact is Mr. Mabe is no longer the owner of the property as a result of a foreclosure action, period. And the conclusion is the board doesn't have the jurisdiction now to approve a site plan and hear an appeal on approval of site plan.
Let's do this. I'm actually leaving town as soon as I get out of this hearing, but I'll be back on Monday, and either Monday or Tuesday, as soon as I get a chance, I'll strip this down, send it to you, we'll agree, we'll submit it. How's that?
That would satisfy me.
Okay, so when both of you agree, then you'll send it to us for approval, and then at
Correct.
that point, I'll sign it.
Correct.
Correct.
And I don't have a problem adding the language, which we really should have added about refunding the appeal fee.
So are
Let's
we
not put
tabled,
that in this agreement. Let's keep this agreement simple.
Okay.
are we tabled again then, until this is done? Or do you need a
No,
motion?
You make a
No.
decision, we'll
Yeah.
agree on the order to memorialize the decision, if you will.
Mr. Attorney, can you perhaps fashion language for such a motion for one of us to take up?
I think the motion would be to approve staff recommendation with the basis of the approval that Mr. Mabe no longer owns the property because of foreclosure, and he no longer, and he does not have the permission of the current owner to go forward with his project.
Anybody want to forward that motion?
I'll forward that motion.
Second.
Any discussion?
Mr. Chairman, just one item, if I might. Should the motion include authorization of the chairman to execute the to-be revised order?
It'd probably be a good idea, yes.
When approved by both parties in form. Okay? You got that? Okay, I see a head nod over there. So we need to amend the motion.
Amend it.
Second.
Discussion? All in favor?
Aye.
Aye. Any opposed? Okay, we're on to item number 2. Thank you, gentlemen. The second of our public hearings this evening is a consideration of amendments to the Land Development Regulations, Chapters 901, 911, and 912, to change the limitations for size of commercial vehicles and recreational vehicles parked outside in residential areas. Anyone who is going to give testimony this evening will need to stand to be sworn in.
Mr.
No?
Chairman, I'm sorry, I made a mistake
Okay.
earlier, thinking that this was a
This is
quasi-judicial matter.
legislative.
This is legislative.
This is legislative.
There'll be a public
Okay.
hearing, so
It's
there's
a
no
public
need
hearing.
for swearing in, and I
Thank you.
apologize for that.
Stan, are you going to give the presentation for the county this evening?
Yes, Mr. Chairman, thank you. The proposed amendment affects commercial vehicles and RVs parked outside residential areas. Just a little recap of why we're here tonight. In February, the Board of County Commissioners heard a request from Ron Heen, who owns property in the RS6 single-family zoning district at 1046 22nd Avenue in a residential subdivision. And at that meeting Mr. Heen asked that the board consider changing certain regulations regarding the height of commercial vehicle. And the board seemed inclined to grant that, but wanted staff to come back with analysis. Staff did that at the March 19th board meeting. Board looked at staff's analysis and then directed staff to initiate the LDR amendments that are before you all tonight. 2 changes were directed by the board and are incorporated into the proposed ordinance. One change would increase the commercial vehicle height from 9 feet to 9.5 feet, and the other would update and essentially increase the current recreational vehicle maximum length that's at 32 feet. Just a little bit of background. These are some photographs the board saw. One of the commercial vehicles at the Heen property that I believe is to be removed and may be removed at this point entirely from the property. There's another view of it, again, at his residence in a single-family zoning district. This is the commercial vehicle that he wishes to retain and keep parked in his driveway, but it does not meet the 9-foot height requirement. It is just under 9.5 feet in height. It meets the length requirement by a few feet. In 2008, the county actually changed its commercial vehicle regulations to be what they are today, and one of the reasons for that is the old regulations back before the 2008 changes had a tonnage capacity rating, and that really was not reflective of really what vehicles are appropriate or not appropriate in residential subdivisions. And so the ordinance was changed, and it was meant to allow kind of small scale to almost medium scale trucks, a single truck in a residential area if the owner of a business lives there. The changes that were done in 2008 specifically prohibits certain types of commercial vehicles being parked outside in residential areas, bucket trucks, dump trucks, semi-trailers, and tractors. And then for other types of vehicles, like a large maybe van or a box truck like Mr. Heen has a pretty high gross vehicle weight threshold, length of 23 feet and height of 9 feet. And those are the changes that were made. The intent of those restrictions, again, is to allow certain size commercial vehicles at a residence, but only one, to prevent large out-of-place vehicles and from basically an aesthetic nuisance being created. Also, one of the reasons we went to certain dimensions was that it could be easily measured. It would be a standard that would be easier to enforce that way. Staff's research earlier this year looked at jurisdictions that had dimensional maximums for commercial vehicles and found that the county 23-foot length is pretty much in line with what we found to be an average of the jurisdictions that we surveyed. With respect to height, Indian River County's 9-foot height is right at the average that we found looking at allowances in other jurisdictions. And our conclusion was that the current length and height limits are reasonable. Increasing the height to 9.5 feet is also within reasonable limits and would accommodate Mr. Heen, but also anyone else in the county with a similarly sized vehicle, because this would be a countywide change. It's also staff's really observation that making multiple incremental changes could be substantial. In other words, this is a very small change, and in and of itself might not be very noticeable, probably would not be very noticeable. But again, if multiple changes are made over time, then the effects could be substantial, and there will always be vehicles on either side of these dimensional limitations. At some point, of a commercial vehicle has to be parked at a commercial storage area or in a commercial zoning district if it's beyond these thresholds. With respect to recreational vehicles, another component of the proposed ordinance, most jurisdictions that we surveyed earlier this year have no RV length limitations. They just go by the standard kind of definition in most states of what the maximum size of a recreational vehicle, which is 400 square feet, if you look at the length times the width. Our conclusion is that our 32-foot length limitation is outdated. It's been on the books for a long time, and there are a lot of RV models that are between 32 and 38 feet. The Planning and Zoning Commission a few months ago looked at this particular type of change and was supportive of it. It was put into an ordinance that ultimately, for other reasons, was denied by the board, but we're asking for your consideration. The proposed ordinance simply does two things. It would increase commercial vehicle maximum height from 9 feet to 9.5 feet and replace the RV length limit with a 400 square foot size. Staff's recommendation is that the Planning and Zoning Commission recommend the board adopt the proposed ordinance. I'd be glad to answer any questions that you might have, and I believe there are people in the audience that wish to speak on this.
Does anyone want to ask questions of staff before we open it up to the public?
I have a couple questions. One is, when you do the analysis, and you have an analysis of Chesapeake, Virginia, Fairfax County, Virginia, how do you select those?
Right. First of all, we go online to a couple of sources. Besides just search engines, Planning Advisory Service is a publication that a lot of planning departments subscribe to, as do we, to look at are there jurisdictions that have dimensional limits like ours. And that's really what we tried to focus on. Surprisingly, it was surprising to me that not that many in the country have dimensional, easy to measure limitations, but that's why we focused on those.
My second question, are these code violations complaint driven? What triggers a code violation?
Right, it varies. Many code violations are complaint driven. Neighbors, people that go by certain, they're kind of the eyes and ears, and we have a pretty active program actually, and access for people to contact code enforcement. And then we always check it out to see if there is compliance. But there's also cases where a code officer just in an area sees a violation. That tends to happen on the more traveled roadways, but back in subdivisions, it tends to be complaint driven.
And so now changing to a 400 square foot footprint, would the code enforcement person just go in and measure?
Correct.
And calculate it?
That's correct, just like they would now with a 32-foot.
And so if it comes out to 405, it's in violation?
That's correct. We doubt that for any models we are aware of RVs that they would exceed that, or they wouldn't be on the road or would be classified differently than a standard RV.
Any other questions of staff? Okay. We're gonna open it up to the public, so.
Mr. Chairman?
Yeah.
Stan, I've seen on I-95 where you will have a large bus-type RV towing a very large trailer, usually painted the same way. Would the trailer be allowed on the lot as well as the RV?
No. We would look at the kind of the vehicle as a whole, including the trailer, in that situation.
Okay. Thank you.
Can I see a show of hands of how many people want to speak tonight on this issue? 1, 2, 3. All right, I'm just going to start on the right, and we'll just come this way. So please come up to the dais and just state your name and address for the record, please.
My name is Charlie Searcy, 1035 22nd Avenue, which is right across the street from the piece in question here.
Yes, sir.
I guess I have some problems because I've had to look at this situation for years, and it just seems to get worse and worse. The issue tonight is the size of the trailer, and I understand that. But if you look back at the record for the number of violations on this particular property, I think you need to take that into consideration. But I would like to take issue with the staff on a couple of their issues here in their analysis, and I think they were comparing it to Virginia or somewhere as far as the height limits go. And typically appraisals, and I'm not an appraiser, have done some appraisal work in the past, but appraisals would not, for example, on the, can you put the slide back up there about the Chesapeake, Virginia, the size, the height limits? Typically, an appraisal would not take into consideration the very low and the very high. They would throw those two out. And I've not seen an appraisal where you use the current size limit, which is the county's. I would throw that out if I were an appraiser. And so if you look at just the Fairfax, Virginia, and why y'all use Fairfax, Virginia is amazing to me. We had Fort Pierce and all the other cities around here. If you look at Fairfax, Virginia, and Manatee County, Florida, and you average those two, you're going to come up with 8.5 feet. So I would sort of take issue with that. And the other, I guess the issue that in this backup says that commercial trucks and vans will not stand out and establish an aesthetic nuisance. If you folks were in the unfortunate position that some of us in the neighborhood are, that are in an older neighborhood where the property or the homeowner association regulations were made back in 40 years ago, you wouldn't have the teeth in those regulations to stop this kind of thing. And I can tell you it's an aesthetic nuisance to have a 9.5-foot sign staring you in the face every morning whenever you come out and look at, and every night and on the weekends and all.
You have a homeowners association in your neighborhood?
We do.
Yeah, are those documents, could they be amended?
Well, I think there's about 50 or 55 people in the association, and I don't know the answer to that. I can't answer. Surely anything can be amended if you can get 55 people together. But the problem is whenever you create a new subdivision, before you sell the first house, you have your homeowner association regulations in place. Now you've got to go back and convince 55 people, or 50 or 55 people, to change the regulations. And you know as well as I do that getting 55 people to agree on anything is going to be a tough sell.
You think it's 100% of the homeowners is what your documents require in order for them to be amended for something like this?
I do not know. I don't know.
Okay.
But I can tell you that the folks in our neighborhood don't want this item to be changed to allow that 9.5-foot height limit. If a person wants to have a commercial business, they need to have it in a commercial site. This business is run from this person's house. And I don't know why we got 160,000 people or so in this county, and we're going to make a change to the zoning ordinance for one person's request. You got to have more than that if you want to put a stoplight in where you've had 3 or 4 people get killed. And I just think that you need to look at it real seriously. This is not a commercial district. It's a residential area. We need to keep it residential, and I would appeal to you guys and gals to make sure that that is the case and this doesn't get changed tonight, or doesn't get recommended tonight, I should say. Thank you.
Thank you. Would you just state your name and address for the record, please?
Dennis Green, 1045 21st Court, Vero Beach. I have a handout I'd like to give to the board. It has photographs.
Please do.
Okay.
Bring it on up.
Do you have a copy for the clerk as well?
Yes, I do.
Very good.
Mr. Green, maybe you want to slide over to the overhead projector so that as you speak, if you're going to reference the pictures that you've given the board, Stan will help you put them up there so that everybody in the audience can see and you can explain a little bit easier with the commissioners as well.
Sounds good. Thank you.
You're welcome.
Okay. These are the originals. I'll be calling them out in my narration. It should be rather plain. Okay, this visit is regarding the proposed 9-foot to 9.5-foot commercial truck height restriction in residential neighborhoods zoning change, the zoning change. The presentation I have is in 3 parts. It's relatively short. Have a distribution of neighborhood photos, which are given to you now. I'll be making some descriptive aspects of the photos, and I would be pleased to answer committee member questions as they occur.
Thank you, sir.
And I have a summary.
Okay.
The group 1 photo is what I would like to speak to. Okay, that should be the homes facing east. Group 3 excuse me, the three groups are, group 1 faces east, group 2 faces west, group 3 is more details of the place under consideration. Undoubtedly, human nature is you've already rifled through the photos and figured that out.
We're a little ahead of you. We're a little ahead of you.
Figured as much. Group 1 is what I'd like to talk to, and there's the ones facing east. These are showing tidy houses and yards, and it's really remarkable that there's nothing to remark on. The picture's oriented such that the upper right is the northernmost house on the street. The one to the upper left is the next one going south. Going to the bottom right-hand corner is the next one going south, and the last one is the fourth house going south on that street. Again, nothing really remarkable. Tidy houses. People who live there drive cars, Suburbans, small pickup trucks. Moving to group 2 facing west. Since the planning and zoning activity began many weeks ago, this side of the neighborhood has improved, but 1046 is still discordant with the neighborhood. The organization here is, starting in the upper left-hand corner, is the northernmost house. Upper right-hand corner is 1046, the property that we're concerned about. Lower left-hand corner, continuing south, is 1046's neighbor to the south, and then on the end of the street is the house on the lower right-hand corner. Upper left-hand corner, that definitely matches pretty well with the houses that were across the street on the previous slide. Lower left-hand corner, more of the same. Lower right-hand corner, definitely the same. And I'm somewhat pleased to point out that on this particular aspect, the upper right-hand corner does look pretty good. Much better than it has.
I'm sorry, could I ask a question?
Yes,
between 1 and
please.
2, isn't the 1105 picture the same? I mean, on one you have it facing east and on one you have it facing west, but isn't that the same picture?
I'm having trouble understanding that. Oh, we have had a faux pas. Yes. That is a error on my part. Their house that is due north of 1046 is very similar. It's White House, similar laid out, and in the process of putting it together, we looked right through that. It's one of the hazards of being very familiar with the area. Just looked right, so we went ahead with it. So I apologize for that. I assure you that the error is on number 2, and it is correct on homes facing east, number 1. Good point. I'm glad you noticed that. Moving to group 3. The yard portion in the foreground is a driveway to park a truck or work trailer north of the house. The usage, the rate of usage, has prevented grass from growing. The ruts have been smoothed, so it looks good here. And the tree droppings have lightly covered the ground, which obscures the dirt. And today, pickup appearing to be in about the 110 category, was parked north of the house. So it is an active driveway in the sense that there is a automobile on the other side of that dirt. Going to 3 through 5, again, these are all 1046 with different aspects. You'll notice that a recently installed concrete pad goes within inches of the south lot line and gives the neighbor to the south most of whatever tropical rain runoff we'll have there. We have had a wet spot in that zone, and looks like 1046 has solved his problem and given it in spades to his neighbor. The pad does provide access to a large metal building. In number 5, you can see the metal building behind the garage. And today a work trailer is parked in the southeast corner of the fenced yard, adjacent to the metal building. The trailer is in view above that fence. It's not apparent on the picture, but I live in the lot behind this building, this property, so I get to see the top of this trailer. Now, that was a basic number of facts. I hope to tie some of them together in summary here. The business operating out of 1046 22nd Avenue has grown in activity and materiel beyond what is appropriate in a residential neighborhood. By materiel, I mean the machinery, the tools necessary to conduct the business. Now, the business has prospered such that it can add the vehicles and trailers that must be required by it, and the pavement to support the vehicles and more storage, the building, have been provided to support the business. The large box truck stands out, slide number 5 there, and it should not be in the neighborhood. There is no vehicle in the neighborhood of commensurate size. That is the largest thing in the neighborhood, and it is an eyesore. The north front yard that you've seen is a de facto dirt driveway. The vehicle usage has not permitted grass to grow. Business must be good. Work-related vehicles should be elsewhere. The south property line is defined by a fence and the concrete pad edge. The planning process, the permitting process anyway, must have broken down to allow 1046 to transfer a drainage problem to 1036. But business must be good to need so much concrete for so many work vehicles. The metal building and parking area for the work trailer seem to be work-related. The trailer gate noise and the noise attributed to moving stock from the metal building to the vehicles should be moved elsewhere. I asked the Planning and Zoning Board to not change the height restriction on commercial vehicles in residential areas. Thank you. Any questions?
I have a question, Stan. I know this is relatively unscientific, but please let me know. In these photos, other than the current height restriction that we're talking about, are there any code violations here?
Yes, we referenced.
Do we have a setback problem with the concrete, the metal building in the back, the parking in the dirt part in front?
I think the primary violations were, one, the size of the two trucks, that there were two trucks, and that there were vehicles parked not in a driveway. Additions to driveways and the width of driveways are allowed to be wide, and up to in terms of the addition for a driveway, that can be permitted, and it can be up to as close as 2 feet from a side property line, as long as it's not within an easement. So there were multiple violations on the site. This is just one aspect, and I believe compliance would involve having only one commercial vehicle on the site if that vehicle meets whatever dimensions are allowed. Not to have two, and not to have vehicles
Steel
parked
building in the
outside.
back with commercial activity going on in it is...
Well, again, I can't tell you what activity there is day to day there,
Right, yeah.
and so there is...
Make an assumption, if it were,
Yeah, if it were, that would be a separate violation.
that would be a separate violation.
That's correct.
So we do have current laws on our books that, I heard you mention a number of things that you were perhaps rightly, and the neighbors were perhaps rightly unhappy about. You do understand what Mr. Bowling has just said, is that those are currently violations of the rules and laws that we do have on the books, and there are remedies for those, which you're going to assure us that you would act on that if, in fact, those were, you were to find that there were code violations.
That's correct. If we find there are...
So the county's prepared to work with this neighborhood to clean up any code violations that there may be. I mean, we're just talking about the height of the trucks here.
That's correct.
He's talking about a number of other things.
That's correct. The only thing I would mention, and I appreciate the pictures, again, this is not about a specific site. If this ordinance is changed, it happens countywide. And I think one thing that's certainly instructive with the pictures this gentleman showed was just the scale of the truck. And what the truck that you see there would just meet the height requirement. So at least
proposed or the
proposed height
the proposed,
requirement, correct.
10-4.
So to give you an idea of scale.
May I have another
Please,
point
please. Yes,
to make
sir.
here? The basis of need for these regulations is to preserve the quality, the aesthetics of the neighborhood, the pleasantness of living there. And perhaps the 9 foot is arbitrary, perhaps it should have been 8, whatever. But it's a means to keep large vehicles out. If a situation goes such that you let a little guy with one vehicle kind of get by because there's a little guy, well, he grows, he gets bigger and bigger and bigger, and it just gets out of hand. You have a fine industrial area down along Oslo Road where people park their vehicles every day. They may drive their pickup truck home at night, and they drive to work to Oslo. They get in their larger vehicle. There are warehousing down there, warehousing facilities such that they can keep their stock down there so they aren't slamming doors up and down, moving stuff around.
No.
The existing laws are good if they're enforced.
Right, and
you've got a good number right now.
Tonight, we're here to determine, although it's all connected, I understand, the specific issue of the vehicles and their dimensions and heights, okay? And I understand, believe me, I hear you loud and clear, your frustrations about the other things. And that's why I wanted to put on the record for you to avail yourself of the resources of the county to enforce our laws and the codes. That's the remedy for all the other things. All the other things, we have no remedy for.
I am here. You probably will hear from our neighborhood again. Thank you.
Yes, ma'am. Yeah, well, you just need to come on up and state your name and address, please.
Hello, my name is Sandy.
Come on, speak into the microphone so we can.
Sandy Heen. I live at 1046 22nd Avenue, the
Hi,
house
Sandy.
that everybody's talking about. This is becoming a personal.
And you are?
I am the homeowner.
Ron Heen. Hi,
Yes,
welcome.
homeowner, business owner.
Yes.
This is about changing the law, and this is becoming a neighborhood persecution.
Personal thing.
One at a time.
I work at people's houses from sun up till sundown. I don't
And
work
sir,
at my house.
Sir, could you identify yourself for the record, please?
Ron Heen.
Okay, thank you.
I don't work at my house. I work at people's houses. I do tile jobs, and I work from like 7 o'clock to 9 o'clock some nights, 10 o'clock. And I don't work at my house and in my shed. That's, that's personal storage. I mean, he's
Well, that's
making
not,
it sound- he's making it
that's not
sound
our
like I'm
issue.
doing
We don't
tile
need to
jobs
talk
at home.
about the storage or anything like that. We're talking about the height of the vehicles.
I know, I'm just
If you
taking
want to
issue
talk to
with
the
it.
code violation guys about what's going on in there, that's not in this forum. I mean, we can't do anything about that.
Like you
know.
said, this is for the truck law for 9 to 9.5 feet.
For the
and I've
whole
got-
county, not
I've
for
got
the
the whole
neighborhood.
neighborhood here. It's like 4 against 1. Personally, I'd like to move out of the neighborhood, but I can't afford to. And it's like, I feel like I'm ganged up and not even welcome in my own neighborhood. And it's not, he has a big airstream. I don't care he has an airstream. He lives on the other street. He doesn't even have to go up and down my street.
I'm going to say this. I'm sure all of us, if I can speak for all of us, can understand the frustration on both sides of it. And you really don't even need to express it. I understand it. I really do.
I've lived in that house since I was 15 years old.
Mr. Heen, I have a question for you, please. What is the significance between a 7-foot box, an 8-foot box, 9-foot box, as far as your trade or any other trades? What does it matter?
It's just a box truck. I mean,
What fits in. And honestly, we didn't know there was a law on the height. We didn't know there was any height law until it became an issue. The other truck that we had, the white truck that you saw in the first picture, which is long gone, was much bigger. We had that truck on the side of our house for 10 years. We never knew there was a height issue. We just bought that truck 5 or 6 months ago. If we knew there was a height issue, we actually would have probably looked for one 5 feet smaller. It's just what will fit in of tools and tile.
Let me follow up with another question. If you buy a pickup truck, whether it be a 3/4 ton, 1 ton, what have you, do you then go and pick out a box to fit on that truck?
usually you buy it just like it is.
It's already
Yeah.
assembled? Okay. All right, thank you.
Thank you. Thank you. Okay. I remember you. Good evening, sir.
Good evening, thank you.
Your name and address, please, sir, for the record.
My name is Jerry Schick.
Hi, Jerry.
I live in 1025 21st Court. I've been a resident in Indian River County since 1947. I have been a resident of Heritage Estates since 1975. This is a residential neighborhood, not commercial. I am 1,000% against spot zoning. Heritage Estates is residential zoned. We don't want a bunch of large commercial box trucks and large trailers parked in our neighborhood. Mr. Heen needs to take all of his trucks, oversized trucks and trailers down to Oslo Road where it's commercially zoned, and leave the residents of Heritage Estates alone. I'm begging you, please do not change the height restrictions in residential zones. Thank you.
Thank you, sir.
My name's Jonathan Rose. I live at 1036 21st Court, also in Heritage Estates. I only want to bring up one issue. It appears that the Planning and Zoning Commission is reviewing a county-wide change to its rules and laws based on the application of one person. It also appears that staff has provided you with only 5 other locations that show some type of height restriction on the trucks. I don't know whether the P&Z has looked into the background of how they came to their law or their rules on the height restrictions of trucks, and whether or not staff has reviewed those recommendations which brought forth this law to then come to this determination that they are suggesting to you that you approve this. But I believe that you're looking at a slippery slope here if you start making county-wide changes based upon a single applicant's request. And it might be in the interest of P&Z to look at these requirements through the lens, or a larger lens, at the needs and the requirements of the entire county before you grant this application. I'm not saying that the application shouldn't be granted in the end, but I think it needs a little bit more review before you make this determination. And I think it would be in everyone's interest, countywide, for you to look into this issue and see whether or not it should be a 9-foot truck, or even a 10-foot truck, or a 5-foot truck. But it appears to me that staff could look into this a little further and provide you with a little bit more information before you make your determination. Thank you.
Well, can I ask you a question?
Yes.
You seem like a very reasonable man. I appreciate the statement you've made here tonight. You guys have a homeowners association.
The homeowners association is toothless. It was put together at the initiation.
There'll be no remedy through self-government.
There is no remedy through the homeowner.
No remedy through
We have a
self-government.
requirement in our homeowners association that everyone have tile roofs. No one has been able to enforce that. No one attempts to enforce that. No one actually attempts to enforce any of the rules of the homeowners association. Most of the homes there were built in the early 70s, and the number of people paying dues to the association might be 30 or 40% of the people living there. So to ask the homeowners association to do what P&Z or the commission might do, it would not work.
That's a shame.
Well, it's an old neighborhood. It's a very nice neighborhood, but that's not the issue here. The issue here is making a county-wide change to rules based upon a single applicant's request. And I think that's what you should be looking at.
Is that a fair characterization, Stan?
Yeah, it certainly is. I think the point's been made a few times is, anyone can apply as an individual for a change to the code or have the board in this case, direct staff to initiate the change. But that's correct. The Planning and Zoning Commission should be looking at this as applicable countywide.
But this is derived from one man's request?
That's correct.
That's correct.
That's right.
And that's not unusual. If the board recalls, the issue of the accessory structure was brought up before. That came as a result of one person's request as well.
But in this case, it would really, in this particular instance, and we are mindful of the countywide implications, it's really only, there's a couple of things we're talking about changing here. It's the 9.5 thing that would apply to this. Like the RV change would...
Well, it's conceivable that in this very neighborhood, there could be some RVs that are more than 32 feet long now. We don't know. There have been no complaints. Code enforcement is not out there measuring RVs parked in driveways. So, you know, I don't know what the effect would be.
This gentleman, under the current code, is only in non-compliance on the height.
Correct. That's correct. In terms of that truck.
And this request has come down from the Board of County Commissioners.
That's correct.
And the rationale is that vehicles have changed so much since this code was written, that needs to be addressed.
Well, I think two things. One is we did change the code in 2008, not that long ago, to establish a height. I think the board's looking at this as a minor change to the height. I think the board wants to accommodate small business owners basically being able to operate, and I think that, you know, they see this as potentially not a major change, but a help.
And in 2008, the height was changed to 9 feet.
Right. We had no.
From what?
Well, we didn't. We only had a rated capacity for that type of vehicle, which actually was at cross purposes with most larger pickup trucks that people have now. So what we tried to establish was, for the first time in 2008, dimensional requirements that would be easy to measure, easy to quantify. And we felt we set up reasonable limits. And I think the surveying that's reported bears that out. But again, the change is pretty minor that's proposed right now, and that's still close to the averages.
Can I just take a quick poll here? We have two things that we're asked to decide on: the height, and then the RV length and 400 square feet. Of the people who have objected and spoken at the podium, if you object to the RV part of it, raise your hand. Okay, so there is an objection to that. Okay, can we hear what that is, please? I just wanted to see if there was a, bifurcation here on this.
It's really just a point. I don't have a dog in that fight, but my question is, right now the limit is 32 feet.
Yes, sir.
And you're going to change the verbiage on the rule from 32 feet to 400 square feet.
And a maximum 30, correct, that's correct.
But if they go with 400 square feet, you can have, based on what I read, you can have a motor home or RV in your front yard 42 or 47 feet long, whatever, 8 feet divided by 400.
I don't think in your front yard.
I'm sorry?
I don't think you can have it in your front yard.
Driveway.
And your driveway.
In your driveway. Well, that's normally where you would park a motor home on your concrete driveway, I would assume.
Okay,
I'm not a motor home guy.
That's not the front yard.
Okay.
Okay.
But if you, with this change, going to 400 square feet, typical motor home is about 8 feet wide, if I understand them correctly. That means you could, somewhere on your property, have a motor home of either 44 or 47 feet long. So that's, again, I don't have a dog in that fight, but that's a huge difference between 32 feet and 47 or 45 feet, whatever the division is on that.
Mr. Chairman, Stan, is there a requirement that the commercial vehicle must be parked in a driveway under our current code?
Right, yes. If it's stored outside of a garage or a carport, it's...
I know tow trucks are required to. I was just wondering if a truck, a commercial vehicle, box truck had the same requirement. I don't see it in 911-15-3A.
Isn't that the answer to this question?
One commercial vehicle exceeding 20 feet. There's one.
We'll get back to you on that.
I think it's covered in 91207, that it has to be parked, or that it can't be parked on the street or something else.
Residentially used lot.
Okay.
I
There you
think
go.
that's correct, but we can get back with you on that.
All right, thank you.
Okay, shall we discuss this? Does anybody weigh in on this? What are your thoughts? Where are we headed with this? Come on, Todd.
Frankly, I don't see an issue with it. If you got a small business owner, times are not that good right now, and they need to store a truck of that height on his property, and it's one truck like that on his property, I don't see an issue with it. I don't see an issue with the change to the RVs either. And that's just my opinion on it, from what I've read and what I've seen.
I don't see a difference 6 inches, especially if you're looking across, far across your street. How can you see 6 inches?
And the RV?
That doesn't bother me either.
Yeah, I understand the issue of commercial vehicles and a lot of commercial vehicles. I understand that. And I think that this is designed to make it a little more flexible for commercial vehicles, and so I don't have a problem with it.
Well, Mr. Chairman, if I can make a motion, I'd like to make a motion to approve both the 9.5 feet for commercial vehicles and 400 square feet for RVs. Can I get a second?
A second.
I'm going to tell you, I'm not in favor of the 9.5 feet, but I'm in favor of the RV.
How come?
I just think residential areas are residential areas, and this is just an attempt to accommodate one person, and
Well,
I'm not.
At this point, it's one person. You don't know until people start calling and complaining. It might be.
I don't know that there's a groundswell of support for changing.
I just don't see the difference. Either say no commercial trucks, period, but to go for 9 to 9.5 is, why don't you say they can't be green, they can't be ugly, they can't be this, they can't be, I mean, you're just 6 inches.
It's not significant. If they were saying going up a foot or going 1.5 feet up, yeah, that is significant. It's noticeable.
They can't be neon, they can't be this, where would you?
6 inches is just it's not that significant, in my opinion, to turn it down.
But you're asking us to change a countywide thing I mean, it is going to make a difference to these people. I mean, it is going to make a difference to these people. So it does make a difference. And I guess if there was a strongly compelling reason to add 1/2 inch, 6 inches to this thing, I guess I could be convinced, but I'm not sure there's that strongly compelling of a reason to make this change.
With the bigger truck they had, they went to a smaller truck, which is in much better condition. You would think the neighbors would be happier.
Right.
It doesn't comply with the code.
Well, all code changes start somewhere, and it's usually with one person coming forward and not requesting that change. It doesn't necessarily start with an upswelling of constituents coming into the commission chambers asking for change. It usually starts with one person. At least that's my experience.
Help me out with this. We have a motion.
And a second.
And a second. It would take all 4 of us to make anything happen tonight.
That's correct.
So, and then I don't know, if we vote and I were to say no, that would kill the whole thing, including the RV thing.
It would be a recommendation to the board to
Correct.
not adopt and
Thank
not
you.
approve.
To not adopt or not approve. At that point, could another motion be made to divide the two, or is that it?
You could do that, yes.
Any more discussion? We ready to go to a vote?
Is this something we can table and bring it back until we have a full quorum here, have 7 commissioners, or
You
something
can
we
do
have to
that,
make a
but-
decision on tonight?
What we typically do is when there's a motion, when there are only 4 people here, and a motion essentially would pass with a 3-to-1 vote, what we're going to do is we're going to report the results to the board. We're going to say there was not essentially there was not a decision because there were not 4 positive votes, but there were 3 votes for this motion and 1 against. And
This is going to go to the county commission for final adjudication.
Exactly.
With our recommendation.
Correct.
And that'll be it.
Correct.
And we can either have 2 votes or not.
Correct.
That's right.
You guys ready to vote?
I'm ready.
On the first motion? All in favor?
Aye.
Aye.
All against? That's me, no. I move a motion that we divide this into
Nope.
2.
You can ask for a motion.
I'm sorry,
to make a motion
I asked for a motion that we divide this in 2 and that we recommend to the county commission the approval of the RV language, but not the additional 6 inches on the height of the commercial vehicles.
Or would someone, or Mr. Chairman, would you want, I think we're clear that you don't like the idea of the larger boxes for the trucks, but maybe you might find consensus among the members as far as the RVs. Would you like a motion?
I'd like a separate motion on just the RVs. Thank you very much for that
The only
recommendation.
bit of discussion I have on this is, what's more of an eyesore, 9.5 feet on a commercial vehicle or a 400 square foot RV? I mean, really? What sticks out more to you? That's why I just see it as if you don't have an issue with one, I just don't see why you have an issue. You're okay with the other. You got a problem with one, but not the other.
I'm in favor of, I'm going to say again, in my mind, there's not a groundswell of support for making it 9.5 feet. There's not a compelling reason to change it. And in general, I'm inclined to leave residential areas residential. And that's just my feeling about it. I think you have a reasonable point about the RVs, but I think I think there is a compelling reason to change that, because the fact is RVs are just bigger these days, than when they were back then. And I think it's just an outdated code, and that's my reason for believing that should be changed. But if the motion's not going to be seconded, it'll just die right there.
No, it's fair enough.
So
I'm going to make a motion that the
chairman-
RVs...
You have to ask somebody to
I'm
make a
going to ask
motion.
someone to make, I'm sorry, I'm going to ask someone to make a motion that the RV as a standalone thing, the language be approved. No motion is made. I think we're done here tonight.
Except for staff.
Stan, anything else going on?
Just that, in all likelihood, we'll cancel the May 23rd P&Z meeting, so this should be the only meeting this month. We will have a meeting on June 13th, the normal first meeting in June. We think we'll have a few projects and another land development regulation amendment dealing with mixed-use regulations. And that's all that I had.
Stan, if I could just clarify what happened up here for the people that are interested in watching. The chairman cannot make a motion. So that's why he cannot go ahead and make a motion that would receive a second and a vote. He has to ask the other members of the commission to make the motion for him. He could then second that motion, but since no other member sitting up here tonight decided to make a motion on behalf of the chairman, the matter died for lack of a motion. So you can include that in your reports, I guess.
Attorneys matters?
I have none, sir.
We're adjourned.